talk about a lot, but I gotta say I don't enjoy talking about that much, just because it's a very fraught topic. But unfortunately, for better or worse, it's something that we have been dealing with in society, I think, a lot more directly and forthrightly over the last decade or so. We brought together a great panel today to talk about harassment, abuse, and molestation cases and insurance claims that result from those cases, both from an insurance coverage perspective and from a defense and resolution perspective. So I'm a partner at Anderson Kill. My experience comes in the insurance coverage realm. Jorge Aviles is is a partner of mine who's also experiences in that realm, and we're really pleased today to have Stephanie Schwartz from Hatfield Schwartz.
Not from Anderson Kill.
Not from Anderson Kill. A completely new, fresh, and thoughtful perspective to talk about how these cases work from a defense counsel perspective.
Thank you.
It's, in my experience, been very important that there be a organic, comprehensive, client and resolution-focused, victim-focused as well, approach to understanding, addressing, and dealing with these cases. And so defense counsel plays an important part in that, and so does insurance, which is, I think, part of what's really helpful in giving this presentation. So quick overview, we're going to talk a little bit about the context in which liability and these claims arise. We're going to talk about the types of insurance that respond to these claims. We're going to talk about some of the challenges that policyholders occasionally face in ensuring that their coverage is there to the full extent that they need it to respond to these types of cases. We're going to talk about strategies for working with your insurance companies and getting the full benefit of their expertise and the value of their policies in addressing these cases, and then maybe give a couple of warnings about places where insurance companies overstep and how to avoid and address problems that arise where insurance companies might start to overstep.
Necessarily occur in the school or the building does that coverage or the exclusion, I guess, and that's what I think we faced as well.
Yeah.
Yep.
That happens a lot.
Yep.
So working with your insurance company, like I said, insurance response to these cases. There are adjusters who work for insurance companies that work almost exclusively on these cases, and they know a lot about them. They know a lot about how to investigate them, they know a lot about how to value them, and they know a lot about how to get them resolved. And in my experience, it is very valuable that the insurance company can be a terrific asset, not just as a funding source, but also an assistance of addressing and resolving these claims. So developing a relationship and a partnership where you're working together with the insurance company can be very valuable in these claims. We talked about the steps here would be that finding the policies, engaging with the insurance company, establishing a collaborative relationship so that you're working together and they're all working in the same direction. All this can be incredibly valuable. I don't want to take away probably what could be the most interesting part of this conversation, which is Stephanie's point of view. Because you're in the middle of all this,
I am.
So,
So I wrote down some just shocking numbers. First of all, my very first sexual abuse case, I'm not going to tell you my age, but I was shocked to hear that people swam naked in the pools. And I know, and everyone's like, well, but back in the 70s, that's what occurred. I was very, very young then. So, and that's where a lot of the abuse, fast forward, happened for these schools. And if you read the reports, I mean, it was higher education would be the same thing, that, okay, not co-ed, but the all-boys school, they would swim naked. So it's like, you sit there and you think, what happened in the 70s that was, acceptable and the normal, again, not so normal now, like, could you imagine? So I went back and I looked at these cases, which talk about the state got hit, New Jersey got hit for $5.2 million this past year for abuse. In New York in 2024, New York State got hit for $5.4 million. 2022, a public school got hit with $30 million. These are abuse cases. And most recently, an independent school in New Jersey just got the jury awarded $5 million. I do know that they're probably attacking that number right now. There were no punitive damages, but the amount of money this is costing to go to trial is I don't want to know I don't know if they're runaway verdicts or if they're just the verdicts these days, and that's what I think everyone is kind of grappling with, and that's why most of these cases will end up settling before it goes to trial, because there is that ick factor, right? I mean, the jury's they're a jury of our peers, and you sit there and you're really going to put up a case that says, well, we didn't know. Well, how did you not know? And they're just going to poke holes in that, right? Like, the person was there and he was creepy. Well, okay, but he was creepy, but was it acceptable back then? And they're sitting there in 2025 and awarding money. So it is, I think, super important as defense counsel, right, to understand what happens when a claim comes in. And so, immediate action, again, back to the slide, immediately tendering it to the broker, to the insurance companies. Finding what is the investigation process. You have a duty to investigate. Be mindful that in many situations, as an investigator, you then become a witness to the case. So how much should you investigate, or how much should you ask a third party to investigate the claims? And you want to it's very different than work product, right? Because you want to know that as soon as a claim came in, you took steps and you took action, which is, again, preserving the evidence. What could be out there? What is the list of individuals? Who needs to be spoken to? Whether they are still employees or no longer employees. The policies out there. One of my very first sexual abuse cases, I will never forget. Plaintiff's counsel asked a question to each and every one of my witnesses who were teachers and said the following: did anyone ever tell you not to touch the children? And they were like, well, no, I mean, we're teachers. What are you talking about? But if you think about it, no one gave training, right, on not to touch the students. No one, because we didn't think we had to, right? I mean, it's just kind of common sense. But he was able to prove there was no policy out there. There was no training out there. We ended up resolving that case. And what did we do to our clients? We then made sure that the policies were in and made sure that they were clear and that everyone is trained on what you can and cannot do, not touch students. We give training. We represent many independent schools in the tri-state area, and we go training. And, I say to them, don't close the door. Don't touch the students. Don't turn the lights off. And everyone's like, well, we would never do that. But people do that, right? And that's where the allegations come in. And when we now have new people that are in charge, right? And they say it didn't happen here. And if they don't believe or they don't think that it happened there, there's a lot of retaliation that also, which will then impact other laws out there because they're retaliating or going against someone because they've reported it, and oh no, now you've shaken the apple tree. So again, I think that it is very important that once there's been a claim to loop in defense counsel, your corporate counsel, whoever is there helping you and giving you proper guidance.
Yeah, in my experience, it's a little secondhand when it comes to investigating these cases, but it seems that the investigation isn't so much, I'm a defense lawyer, I'm going to defend this case and I'm going to prove that the claimant's lying. I think for these, especially in these historical sexual abuse cases, an important part of that investigative prerogative is to get to the bottom of it, right? It's to find out, did this happen? And if so, what happened? And who could be affected? And how do we fix it? And how do we address it head on? How do we make it better? How do we do what's right? That's, I think, an important prerogative of these claims that is a little different from the way I think a lot of defense lawyers typically approach their job, which is, I'm going to exonerate my client at all costs.
And I think it's important also to have that open-ended investigation because there are victims out there. They're going to come back, and if they see that there's got to be empathy, like lawyers just need to have empathy. You have empathy to these victims. You may, at the end of the day, reduce the cost of the claims because you have to go in there with those listening, right, and making sure that you, as you say, get to the bottom of it, not put your defense hat on. And again, when there's a work product and a privilege, an attorney-client privilege that can attach, and there's also the investigator will then be a key witness to say, well, what did you do when you found out about the claim, and how did you then approach it? So I do think that it is in everyone's best interest to make sure that quickly and efficiently you figure out what the next step is when you have a claim. The worst is when it gets swept under the rug. One of the claims recently, and again, I wasn't involved in the trial, so I only read things that are online as well, is that someone took the letter that was written to them about 20 years ago and ripped it up because it was bad for the school. It was bad for their reputation. I think in that situation, not addressing it, why not? Because maybe they wouldn't have gotten hit with a $5 million verdict if someone did something.
Yeah, not helpful evidence.
Yeah, I think it further complicated all this, as we mentioned, a lot of things are really old, so there was no email back then. So your records are very different. How people communicated is very different. A lot of this police written records have been lost. So it's an exercise of memory and recollection and who remembers what and who's around.
No, absolutely. And, look, we would do things different in 2025 than I'm sure that was done in 1975, because we know better. We learn by all this stuff, If someone came, you would immediately say, here are the people that you need to contact. Like, did they do that in 1975, or were they more worried about their reputation? Thank you. It's question.
I've heard questions, actually, because I know that a lot of litigation, especially in New Jersey, there's a decision, I guess, so my question is this. You guys hear me? It's about fun. I can be loud if it's fun. There are state-role sexual abuse policies that are now being offered. So I know that a lot of litigations go back years and years and years to mess it happen when I don't need statute of limitations. Have you guys run into any claims where you're dealing with policies that are in place right now for things that are happening right now? So there's a lot of discussions about that as there are solutions being, put on a lot of these policies. So I don't know if you.
So you guys can just, for defense counsel, the answer is yes.
Okay. What do you think? Are they dealing with their intended to do, or?
Yes. Yes, I will say that. Yes.
Because you have questions, which are that's how much you could possibly do.
Yeah, I mean, and Marshall and I were talking earlier, and I think, and again, it wasn't so much look back, but even when the statute of limitations opened up, people, the 1990s came forward. I felt as defense counsel that the carriers were more willing to write a check when it first happened than they are now, in my opinion, right? And maybe it's because they didn't think that in their budget or what have you, but I thought they were more willing to come to the table, get rid of these cases, than now some of them are not willing to get rid of the cases so early. Now, that also goes to that plaintiffs' counsels have gotten wind of the idea that we can ask for big demands versus what's a reasonable demand. So, again, I think it's just a kind of a balancing act.
Yeah. All right. We're almost out of time, and if there are more questions, I would love to field them. We can also talk afterwards. I put up just in the few seconds we have, I wanted to highlight this issue, which I foreshadowed earlier, that sometimes insurance companies will try to leverage the squeamishness of the policyholder about this horrible situation that they're in to extract dollars where the policyholder is paying towards a settlement. That is not the policyholder's responsibility. If you have a policy that covers these things, what the insurance company will say is, well, part of what you're resolving here, and part of the harm that's alleged involves your reputation, and we don't insure your reputation, and you're getting the benefit of this protection of your reputation, so you should put in some money for that. That's not true. There's lots of cases that don't address this directly, but address it conceptually and say that the insurance company who covers this claim has responsibility for settling this claim, and to think of the totality of the policyholder's interest in settling the claim. So anyone who wants copies of the slides, obviously just let us know. We can get them to you, but I put together a string site over the years to help push back on that idea, because it comes up in mediations and settlement conferences more often than I'd like to admit.
Yeah, another thing insurance companies often try to do, I know we're out of time, but it's say, well, we think 20% might be this, 30% might be that, 50% might be that. But usually when you settle a claim, you don't sit there thinking, well, let's divide this, let's take this amount for this and this amount for reputation and this. Usually you say, we'll give you this amount of money to just settle this whole thing, and you don't piece it out that way. So that's another argument that we often run into, but it's an argument that there's favorable case law for the policyholder to be able to say, no, you cannot come and challenge our settlement. We settled on the advice of counsel and underlying counsel. We understood this to be a good settlement, a good business decision, and so you should ensure our settlement.
All right, well, thank you, everybody. Pleasure being here today, and I hope you guys